This is case number 2006-0150, Lawrence Sleeper versus Warden, New Hampshire State Prison.
May it please the court, I'm Joshua Gordon. I represent the habeas petitioner, Lawrence Sleeper, who presently resides in the county jail. When Judge Fitzgerald was confronted with these comments, he had three choices. One would have been to convene everybody, the jurors, maybe another judge, himself, the attorneys, and hold some kind of hearing. That would have required an enormous presence of mind that perhaps none of us would have had. The second choice would be to delay things, to go in his office or wherever judges go in courtrooms and think for a few minutes, perhaps to bind over the jury to the next day, to do some research, perhaps to ask for emergency memos, to explore his options, to think. And that, I think, probably would have been the most judicious option. What the judge did here was just impetuously discharge the jury without conducting an investigation and effectively boxing the defendant into asking for reconvening the jury, which perhaps is possible, but awful unlikely. And this would have been reconvening after the jury had been polluted by their contact with friends and neighbors and, of course, the press. And that also would have been with the constitutional, Mr. Sleeper's constitutional right to a jury, to a proof beyond a reasonable doubt, would have been left somewhat in doubt.
Why wouldn't that issue then, which you've identified, have been raised on direct appeal, and more importantly, what precluded it from being raised on direct appeal?
Well, it wasn't raised by trial counsel, so I think there is no, under this court's preservation law, there was no possibility that it be raised on appeal.
But it should have been, and it could have been. So why wasn't it? And since it wasn't, why are we dealing with it now?
I think the state's position is that a habeas petition is only good for maybe things like new evidence, but outside of that is only good for ineffective assistance of counsel. Ineffective assistance of counsel here would not help anything. The standard's the same. There's, constitutional rights affecting the constitutional error affecting defendants' rights. And it would merely add an additional layer of analysis to the real issue, which is, did Mr. Sleeper get a fair trial with the correct burden of proof? We would have to go through that ineffectiveness analysis first before we really ever got to the real issue.
Isn't the purpose of the whole process of preservation to put the trial court on notice, to bring the matter to the trial court's attention? And if you don't do that, at least you raise the issues so it's on the record so it can be appealed. I mean, it seems odd that Justice Brennan was considering an issue on a habeas that clearly could have been raised on direct appeal.
Could have been.
And so why isn't that the end of it?
Well, obviously the trial counsel didn't raise the issue and could have filed a motion for a new trial or something. Either she didn't see the issue, or perhaps she was misdirected by the court's demand for memos on impeachment. And it was a demand. The court's comments are, any motion shall be accompanied by a detailed memorandum of law with specific reference to use of jurors' testimony to impeach a verdict. The judge wanted memos on impeachment. Even if she saw the issue and was not misdirected by the court's order, the remedy would be magically go back in time and investigate a now polluted jury. I don't know what good it would have done to say, well, Judge Fitzgerald, you erred by not investigating at the time. What are you going to do about it? The only option left to her was to ask to reconvene the jury. So that it wasn't preserved at the time is entirely understandable. It wouldn't have gotten anything.
What do you do with the notion, at least my understanding of the law, correct me if I'm wrong, that the trial court, Judge Fitzgerald here, was it Judge Fitzgerald?
He was the trial judge.
Had pretty broad discretion. I mean, that's why trial judges are trial judges. We give them pretty broad latitude to make the spot call. And so he decided it wasn't necessary. And then Judge Brennan seemed to be saying, If I were the trial judge, I wouldn't have done that. That's not the test, is it? It seemed to me he was putting himself back as the trial. It's not a reviewing court with broad latitude to the trial court. I mean, that was my sense of what he did.
Well, I don't know, and I don't know what Judge Brennan or any judge would have done in the confronted with this habeas, whether or not ineffective assistance is alleged. But the comments, I don't think they're ambiguous. The foreperson said to the judge that the prosecution put on all this evidence, and the jury kept asking why the defendant didn't put on any evidence that he didn't do it. They obviously got some conversation about that.
Doesn't Justice Brennan have to say, I find that Judge Fitzgerald, based on the facts of this case, abused his discretion or exercised his discretion in an unsustainable way, and therefore, you just don't get to say, gee, I'm troubled, motion granted.
Well,
I mean, that's not the test, is it?
I think he was confronted with the impetuousness of the discharge. And why didn't, there's a duty which is only based on a colorable claim. It's a very low standard in State v. Smart. That all you have to do is have a colorable claim that the jury misunderstood this. It's a very, very low standard. Why wasn't that done? Why didn't Judge Fitzgerald do what should have been done?
And why wasn't that the question on direct appeal, which we come right back around to? There's nothing new here, and we've said many times that a habeas petition isn't a substitute for an appeal.
Well, it's not a substitute for appeal, and the question on direct appeal is very different from the question here. The question on direct appeal...
Well, I know the question on direct appeal is, you say, different. My point is that this very question, the one you're articulating now, could have been asked then as well.
Right, I think I've addressed that. There was, on 4 days later or 2 months later, whatever it was, trial counsel would have had to ask for an impossibility to magically go back in time with an unpolluted jury in order to...
Trial counsel could have said it was error for the trial court to impetuously discharge the jury and fail to reconvene it. Issue number 4. Right?
The trial counsel could have filed a motion for a new trial, raised the issue then, and I suppose the petition for habeas in this case can be just retitled petition for new trial. It was filed within the 3 years, but we'll be back here doing the same thing. I'm not sure that buys anything, and I don't think Avery v. Cunningham, cited by my brother, was concerned with a defendant gaming the system. And Avery knew that he had this issue of competence from the get-go, from the day the trial started, and he went up and down to the federal courts. There's no gaming the system here. It was missed. The issue was missed by trial counsel.
On appeal here, counsel could have briefed the issue as to whether or not it was error for the judge not to sua sponte notify counsel as soon as the juror made the statement. And we didn't need any objection for that. If it's a sua sponte obligation of the trial judge to notify counsel at the end of trial of the statement, you could brief that issue without an objection, couldn't you?
If Chris Johnson raised that, if he did that in a direct appeal, there is no doubt that this court's response would have been that wasn't preserved.
Oh, I don't agree. It would be preserved because it's a sua sponte obligation.
So sua sponte obligations...
to notify counsel of a improper comment from a juror. Doesn't the trial court have an obligation to do that?
The trial court had an obligation to do it.
Sure,
but
as I said to Mr. Court, if this happened in the middle of the trial court absolutely has to call in counsel right away and say, look, the juror said this. And if the trial court didn't, it would be an issue on appeal without any objection.
Well, that's a surprise to me that sua sponte obligations don't have to be preserved anywhere. But whether or not, I think we're putting procedure over substance, is at some point the issue needs to be raised. And whether the habeas petition should have been a new trial petition or whether it's properly a habeas petition, I think is not really relevant. The issue is that the judge discharged the jury when he had not only an obligation but an opportunity to put some questions to the jury. What did you mean?
Is it your view, maybe that's correct, that he had no discretion? Is that your view? That Judge Fitzgerald, having learned what he learned, which is not disputed, when I was talking about giving deference, you seem to be saying that there is no discretion at all, period.
If there's any, it's very, very small. There only needs to be a colorable claim, and that's so small that the amount of discretion is insignificant, I think. So perhaps, yes, it is either very small amounts of discretion or none at all.
Do you agree that we should apply the cause prejudice test to the arguable procedural default here?
Well, I think in order to get to that federal test, which is based on a federal statute, which I find very different from our habeas statute, then, I don't think the analysis ever gets there because I don't believe there's a procedural default.
Well, I understand, but assuming there's procedural default, then you get to cause prejudice in federal court, which I agree it's different because they're reviewing state court convictions.
Right.
And so there are different policy considerations. So I guess my question is whether there should be a different standard for reviewing issues that are subject to procedural default, where you have state habeas reviewing its own proceedings.
I haven't given the issue any thought. I'm sorry.
If you look at the federal test that Justice Duggan is talking about, the first prong of it, there has to be a valid reason for the defendant's failure to raise the issue, and as counsel was suggesting, ineffective assistance of counsel might be such a valid reason, but you're not claiming that here.
Well, only because, as I said, that it's just a layer of analysis that gets to the same issue, and it's the same analysis too. It's just was there a constitutional problem, and did it cause the defendant harm? And I think the answer to both things is probably yes. And whether there's an ineffective assistance claim or not, it's a procedural hurdle that's irrelevant.
This will come back here, you say, on a denial of a motion for new trial.
Right.
We'll be dealing with the issue in some other form.
Depending upon how State versus Looney that you heard last week is decided, yeah. Yeah. I ask that you ratify or just uphold the order that's already issued. Thank you.
Thank you very much. Case submitted. Thank you. The court will be in recess.